Right. Hello, everybody. It is so great to see you all. I'm Athrea Mothra. I work as the Director of Legal Research at the Center for Art Law, and thank you so much for attending today's program and spending the afternoon lunch hour with us in New York. Now, before I introduce our incredible panel of speakers, and as per usual, I'm going to let you know a little bit more about the Center for Art Law and what we do. So the center is a Brooklyn-based research and education nonprofit, and we are dedicated to offering resources and programming to advance the arts and law community through our website, our newsletter, our events, and very recently our Art Law podcast, which talks about art and the environment in our latest episode. We try to disseminate information and keep our audience updated on everything art law, whether it's programs, cases, publications, movies, you name it, and the center hopefully tries to cover it. But of course, this doesn't even begin to describe everything that we do. So we invite you to subscribe to our newsletter if you haven't already to receive updates on our work and to see what all we have planned for the year. You can also consider becoming a premium member and you receive tons of offers, discounts, access to our events, access to our case law database, and very importantly, the recordings of all of our past events. So just saying, a lot of benefits and a lot of information is available in this space at the center. So please do take a look at our website, what we do, and we hope to see you at everything that we have coming up. We do have a lot planned for the year. We actually host clinics where we pair artists with our network of volunteer attorneys for one-on-one consultation sessions. So you're able to understand your circumstances and next steps in different areas. So we have our artist dealer relationships clinic coming up, and we have our immigration clinic coming up as well, early April. We have a workshop on immigration and O1 visas for artists under the Trump administration, a very important topic for now. And we also have a clinic on copyright and legacy and estate planning for artists. We are very excited to announce that we have our annual Art Law Conference that is happening in person in New York and online as well. And we are covering Nazi-era disputed art. We will be at Christie's and we'll be discussing research, cases, litigation in the area, and it'll be a full day of very exciting keynotes and panel discussions, and CLE credits will also be provided for New York attorneys. We are also very, very excited to launch the first ever Center for Art Law Summer School. We're doing a lot of firsts this year, and in May, we will be teaching a whole week of art law, and it will include visits to galleries, museums, auction houses, a lot to learn in the field, covering intellectual property, contracts, provenance, litigation, and this is just to name a few. We'll be hosting bootcamp trainings as well for attorneys who wish to specialize in copyright and in artist-dealer relationships. So a very happening time. And if you have more questions, please feel free to reach out to us or look at our website to see the very vast list of programs and events we have coming up. Now, before I introduce our speakers, just a few of the usual housekeeping items. The program is being recorded for archival purposes, but as I keep mentioning, we would love to see more of you, so feel free to put your cameras on, but your microphones muted for the moment. Once the recording is available, I will share that with you, along with handout and materials for the session, as well as a survey for the event as well. If you have any questions for our speakers, we'll have a question answer session, so you can put them in the chat box. We really do invite you to send in your questions. We always appreciate a very interactive program. Now, finally, to introduce our panelists, today we are joined by Jonathan Henery, manager at Christo and Jeanne-Claude Studio. We have Bob Randall, partner at Kaplan and Karsch. We have Michael Harris, who is a former professor, University of Denver, and who was the attorney for Rohr. And we have Katie Van Heuven, who is also a partner at Kaplan Karsch, and she was the attorney for Christo. So we will be examining the legal battles, the environmental considerations, and the artistic ambition surrounding the Over the River project with Christo and Jeanne-Claude. So you can read all about the incredible work that our panelists have done in the handout and materials, which will be shared shortly. And they have additional reading resources as well for anybody who's interested in art and the environment and other similar projects. But without any further ado, I promise I am done, and I will hand it over to you, Michael. Thank you to all of I'll hand it over to you, Jonathan. And thank you to all of our speakers for being here today. We are very, very excited to hear from you all. Thank you.
Hi, I'm Jonathan Henery. I was just introduced, one of the nephews of Christo and Jeanne-Claude, and I've worked with them for many years and grew up working on Over the River. So I'm very happy to give a brief introduction before these law professionals take over for you. I have a few images I want to show, and I'll explain the artistic vision of the project and the very beginning of trying to figure out how to get this done, if I may. Here, let me know you got that.
Thank you.
And I'll make that look a little nicer like that.
Perfect.
Okay. So in 1992, after the artist finished a major project called the Umbrellas in Japan and USA, Christo made these preliminary drawings for a dream to put fabric high above a river. Therefore, this drawing here, 1992, is just called the River Project. We don't know what, he didn't know the river. He just knew he had to find a river where you could hang cables and fabric high above the water so that you could see through the fabric from underneath, playing with shadows and light. And you can also experience the project from above. As you see, he drew these little characters here. There's a couple other early project from 1992. Again, no river in particular. He's already changed the name here in this one already to Over the River. And as you know, it didn't end up being a project for 4 to 5 miles of river or 5 to 6 miles of river. As a lot of things Christo and Jeanne-Claude do, they grow as they find the site and develop the project. Here you see also people underneath the fabric, clearly right along the riverbank. So now they know what they want to do. Now they need to know where they want to do it. So in the summers of 1992, 1993, and 1994, the artists drove about 14,000 miles, not themselves. Someone else drove, their friends, their engineers, their collaborators, photographers, across the Rocky Mountains. And you see on the map on the left, out of the 89 rivers which they investigated, they narrowed it down in those summers to 6 possible sites. Why were those sites chosen? First, the river had to have all of these elements, which would mean you have a road. The project's an art project. Someone has to be able to see it. It has to be accessible. These projects aren't made just for the birds to see. They're for humans, and they need to be in an environment that's accessible and practical. In other words, you also have an ability to get materials and workers in and out safely and in an easy way. These drawings and collages here are for sites other than the Arkansas River. The top one here, this is for the Piatt River in Idaho, a section of the Piatt River, and the bottom one here is for a section of the Rio Grande in New Mexico, right in that little circle there. In those summers, they measured, literally driving with vans and rubber rafts and ropes and tools, and measured the heights of the banks to sort of see what would be appropriate. They needed high enough banks that the cables could go across safely so that rafters and boaters and kayakers could still use the river, fishermen, etc., but also not be dragging into the water and into the bushes and so on. It's meant to be over the river, not in the river. This, those of you who worked on the project will recognize as a section of the Arkansas River. As you can see, you have here US 50 on the south bank, and along the north bank is the railroad managed by Union Pacific, which turned out to be an important thing to know because you need to know whom you need to get permission. One of them was Union Pacific Railroad. I won't go too much into those permitting agencies because that's coming up next. Here they are measuring with their teammates, seeing this is again the site of the project, parts of the site. It was 43 miles long from west to east, but they did measure. This is all in the 90s. And there's a sort of a highlight up here of the spots along US 50, where the Arkansas River, it's the Arkansas Headwaters Recreation Area, which manages that area along with the BLM and the state of Colorado. And the yellow were the sections where fabric would be between the two counties of Chaffee and Fremont County. And the inset is just sort of the detail on that. So, you know, if those of you don't know Colorado, you're Denver, Colorado Springs, and then west of Pueblo. But this is deep in the mountains in a much more less densely habitated part of Colorado. Here are a few later collages and drawings after you sort of got the idea of more engineering and more development. You have now flyover maps, which they paid for. And then Christo drew with engineering data where the panels would be and exactly where the anchor points would be. And there's samples of the fabric that was chosen. How they get to there Again, working along the Arkansas River, there was a wind tunnel test done in Guelph at the RWDI, Guelph, Ontario. Those engineers also came to our life-size tests, which were done off-site in Western Colorado and again, BLM land, but on a private ranch. And they made four tests between 97 and 99, trying to figure out which type of fabric, what would look better. They tested for water retention, basically dump a water truck on it, see how it holds, how to anchor it, how to hook the fabric to the cables, how to tension it, how to, positioning of guy wires at the ends of the segments. You can see there little guy wires to sort of keep them steady. They had wind monitors on them, load monitors. And another thing that was learned that you can't really see very well, but the engineers knew that they had to get the cables off the ground. So they built designed these metal frames, which end up becoming anchor transition frames, which again allows the cable not to drag in the rocks and the dirt, but keeps it clear and safe high above the water. Again, now you can see a much later drawing sort of being able to raft. They also worked that the fabric had to be a minimum of, I believe, 12 feet above the average water level for safety purposes. Okay, now we know who owns the land. It was the United States federal government. So so they have to get permission. I won't go into great detail, but we found out from the AHRA folks who are joint BLM and state of Colorado, as I mentioned before, that there is a law, NEPA, the National Environmental Policy Act, which guides people's usage of federal public land. So they created this at great expense and time to themselves, this application, JF Sato Group in Colorado. This was then submitted to the BLM, had lots of proposed mitigations, or everything that goes into an EIS without being an EIS. But since this was paid for them and commissioned by them, cannot be used by the federal government as an impartial document. They had to then hire another firm to then analyze that and create their own EIS. So by 2010, the draft environmental impact statement was published for the BLM. And of course, Christo loves data. So yes, we know it's 4 volumes, 1,400 and something pages, followed by public comment periods. If you've ever heard a Christo and Jeanne-Claude lecture, he would give you all those numbers would fly right off his tongue. But this was very impressive because the first time a public work of art had to do this. And they did the EIS mainly because they knew or they believed that there was a chance the project would be challenged in court. And this would give the greatest amount of mitigations and the best chance of survival against a challenge. And finally, in 2011, after the public comment period, the BLM issued their final environmental impact statement, which was then used by the Interior Department to decide on the permit. And there they are. In 2011, you see then Secretary of the Interior Salazar announcing permit had been given, not at the Interior Department, but at the National Gallery, which is under the jurisdiction of the Interior Department. But Jeanne-Claude already being dead, Christo's still just as stubborn. He said, I'm an artist and I want my press conference at the National Gallery. So there he is with Secretary Salazar, Rusty Powell, director of the National Gallery, and curator, dear friend Molly Donovan Young, who's now the acting director of the National Gallery of Art. I'll finish up a couple more beauty shots, which we can use later drawings. Again, lots of engineering data. Here, there's the transition frame, keeping the cable off the ground. I mentioned that before. The fabric samples. And you see it turned. There were breaks in the project when the banks were too low, when there was a bridge, when there were trees, or when the river and the road were not near each other because it would be inaccessible and no one would see it. Those are all my slides for now. And I think, can I pass this off to Bob Randall?
Yeah, terrific, Jonathan. Thank you. Appreciate the background on the project. So again, my name is Bob Randall. I'm with the law firm Kaplan Karsch. At the time of this project, I was an employee of the state of Colorado. I worked for the Colorado Department of Natural Resources for 11 years. During the beginning of this project, I was the federal lands coordinator, and later I was deputy director and then executive director of DNR. I don't have any slides. I apologize. I'm going to be talking about permits and agreements. Nobody wants a bunch of words on slides, and those things don't lend themselves to visuals. So please forgive me, and just thank you for having me. So Colorado has a long history of commitment to public art. It's long been recognized as a role for its role in both the economy and tourism. And during my time working on this project, we very much saw this project in similar terms. We saw it as an opportunity. It was exciting to have a site in Colorado chosen by a world-renowned artist for a project that would attract international attention. Um, that didn't mean that we wouldn't give it a rigorous review, though, and seek to protect the state's interests. I knew that we needed to identify and evaluate all the steps of the project from its planning to its construction, its display and demobilization. I also knew that we needed to rigorously analyze all of the anticipated impacts of the project and seek to address them, either through avoiding them or mitigating them. And I just want to start by saying Christo and Jeanne-Claude were up to that challenge. They had a goal to be sure of realizing this project, but they knew that the process, the planning of every aspect of it, the environmental review, the public meetings, the evaluation and mitigation of impacts was a part of the project, and they truly embraced it. Um, when the project was first proposed, various federal, state, and local agencies entered into an MOU focused on the preparation of the environmental impact statement that Jonathan referred to. I brought my copy of the EIS, the environmental impact statement, as a prop. This was required because the artist needed a land use authorization from the federal government as owner of the land on which the project would be constructed. And so the entities involved in this EIS included the Bureau of Land Management, the federal agency, the Colorado Department of Transportation, which would administer any roadway measures on Highway 50, Colorado State Patrol, which would be involved to address safety issues, the Department of Natural Resources, which again I'll talk about in a moment, and then the two counties that the project fell in, Chaffee County, Colorado, which represents the western portion of the project area, and Fremont County, Colorado, which was the eastern portion. They have responsibility over emergency services, law enforcement, zoning, and all the rest. The BLM was the lead agency for the EIS and convened these meetings that took place in largely in Canyon City, Colorado. Again, I participated in this process on behalf of the state, specifically representing the Department of Natural Resources. And the Over the River project required permission from a few entities within my agency. First, it needed a lease for a small parcel near the western end of the project owned by the State Land Board. The State Land Board is created under the Colorado Constitution. It owns 4 million acres of surface land in Colorado and administers it for the benefit of trust beneficiaries, the school children of Colorado, along with a lot of Western states. It's a common sort of structure. It also required a permit from the State Parks Board as co-administrator of the Arkansas Headwaters Recreation Area. And finally, it needed the review of the Colorado Division of Wildlife for its impacts to the state's wildlife resources. So I'm going to focus on the elements that I helped to negotiate on behalf of Colorado State Parks and Wildlife agencies, addressing impacts both on visitors and on wildlife. First, with regard to visitors, under state law, the Colorado State Parks Board had the authority to regulate activities within the Arkansas Headwaters Recreation Area. Under a cooperative agreement with the Bureau of Land Management, the federal agency, along with the Forest Service and the Division of Wildlife, the Arkansas Headwaters Recreation Area was managed primarily by state parks. The Arkansas Headwaters Recreation Area extends 148 miles from Leadville, high in the Rockies, to the Pueblo Reservoir out on the Eastern Plains, flows through a number of towns, and is one of the most popular river rafting sections in the United States, and provides some of the best fishing in Colorado. It has rapids ranging from Class 2 to Class 5. There are over 25 developed river access areas, 6 riverside campgrounds with over 100 campsites, and many, many trails that serve hikers, that serve bird watchers, rock climbers, hunters, and anglers. And I share that just to say that, yes, this is a remote area, but it is also heavily used and wildly popular with residents and visitors alike. And so in May of 2011, Over the River and the State Parks Board presented in a public meeting a memorandum of understanding to address impacts on use of and impacts on Arkansas Headwaters facilities and visitors. The MOA included first a waiver by state parks on the general requirement that vehicles need to have a state parks pass to use state parks facilities. It included development of a plan to manage boat traffic on the river, recognizing a lot of people were going to want to see it from the river, so both a commercial boat rationing plan and a private boat permitting system. And then payment by over the river to state parks for two things. One was to cover administrative costs like staffing, implementation of the event management plan, and other things. That was a commitment to fund to the tune of $320,000. And then payment by state park or by over the river to state parks of an additional $230,000 as a recreation impact fee, given the use of state park facilities and all the rest. So $500,000 of payment from over the river to state parks for use of this area. It also included a grant to state parks of a 5-year licensing agreement, whereas state parks could sell products commemorating or memorializing the Over the River project. This was a significant opportunity we saw to state parks to create merchandise of various types that would, include a reproduction of some of Christo's original artworks, also a handwritten statement that could be affixed to those products. It was similar to what was done in the gates to benefit the Central Park Conservancy, and we saw it as a great opportunity both to publicize the project and to publicize the state parks resources. So that's to address impacts on visitors. And now I'll touch on the impacts to wildlife, primarily impacts to bighorn sheep. This is a major concern of the state agency. It was a major concern of local residents. The bighorn sheep has been the state animal in Colorado since 1961, so it's beloved and iconic. And the Arkansas headwaters, the Arkansas Canyon provides significant habitat for bighorn sheep. And the habitat through there is largely restricted to just the river corridor. There's some upland habitat outside of the canyon that was potentially suitable, but sheep didn't want to use it because the trees were too dense, allowing mountain lions to hide in the trees. And bighorn sheep are smart enough to avoid areas where they would be insufficiently protected by open space. And so there were some habitat constraints. Also, sheep depended on the river for water. They frequently used the canyon and came down to the river to drink. And so concerns about these factors included impacts on lamb survival and displacement of sheep from what is now suitable habitat into areas that were less suitable. And so the State Wildlife Agency recommended, and we negotiated with Christo's team, an approach that incorporated a few elements. First were some timing restrictions where construction would be avoided during the lambing period, when sheep are most vulnerable, both mothers and babies. That was a 10-week period in the spring, and then no construction during heavy snowfall periods during critical winter time. So there was like a process to measure the snow and sort of call a halt if the impacts would be too great. Second, CPW developed a habitat treatment proposal wherein the artists would fund clearing of a corridor from the river up to some suitable habitat on the side of a mountain, using hand crews from the Department of Corrections, so utilizing specially trained crews from the prison facilities in Canyon City. A corridor was identified that was 300 yards wide, so the width of 3 football fields, clearing the trees. It would take 3 to 8 months to complete. Again, providing a sufficiently wide corridor that sheep would use it to go from the river to some suitable habitat that they hadn't currently used. It included placement of water features and other things to just enhance the use of that habitat. The cost of this project was about $200,000 to clear the land in order to get into suitable habitat. And Wildlife also recommended a monitoring project, wherein sheep would be outfitted with radio collars and VHF collars to track movements through the corridor, try to figure out whether they're being displaced, and if they are, where they're going. And then finally, there was an adaptive management plan that wherein money would be set aside to do more habitat treatments if they were necessary. And so I'm going to total those commitments for those who might not have been doing the math as I went along. But again, it was a covering of state parks administrative costs, a little over $300,000, the recreation impact fee, The lost use of sites and campgrounds came to $250,000. The Habitat Project was just under 200. The monitoring program was $175,000. And then adaptive management, $150,000 was set aside for that. And so all in, the state parks and wildlife agencies requested and negotiated about $1 million worth of projects to address impacts both to sites and to visitors. Now, I will close just by noting that this project saw a fair bit of controversy and support internally. It was somewhat inconsistent. It was supported early by Governor Bill Ritter, Colorado governor, and then later by Governor, now Senator John Hickenlooper. It was anticipated to bring over 400,000 visitors from around the world. While exciting, that has impacts, which led to the discussions that we had. It was supported by local elected officials, including the local member of Congress and state senator. It was supported by New Mexico Governor Bill Richardson because New Mexico saw the potential for visitors coming down to Santa Fe and Taos and other areas known for their art communities. And I'll just note it was initially opposed by both the Colorado Wildlife Commission and the Colorado State Parks Board because of concerns about impacts. And in the end, both of those bodies supported the project, given the artist's willingness to address the impacts. I will just note that during my time at the Department of Natural Resources, I negotiated approvals of many projects and regulatory actions that were consequential and controversial. It included regulation of a statewide oil and gas industry worth billions, some of the largest hard rock mining companies in the world, and water providers, providing water to millions of residents across the West. And never in any of those processes did a proponent so voluntarily and enthusiastically seek to meet the expectations of a regulatory agency. Again, in my experience, Christo and Jeanne-Claude embraced the evaluation of impacts, and they were a partner in seeking to address them, and that was truly just extraordinary. They saw it as part of the process to realize this project. It wasn't just a cost of doing business that could be externalized by raising prices or whatever. It was a part of the art, and that was just, again, something I'd never seen or experienced before. I know I went a little long, so I apologize, but wanted to share that. I will now hand it off, I think, to Mike Harris.
Share my screen here. I do have a slideshow as well. We have a lot of words in it, so sorry about that. Can you see that? Yeah, okay. So my name is Mike Harris, and I have been a litigator for about 30 years now, almost exclusively litigating on plaintiff environmental sides. And at the time, and that means environmental issues, that everything from clean water to clean air. But at the time, in 2012, when this decision was made and this litigation was brought, I was almost exclusively doing public lands law. So it was, one of the things we tried to do, and I was a professor at the University of Denver. I ran the Denver's Environmental Law Clinic. And for those of you who haven't gone to law school, in the last 20 years or so, schools have tried to do a better job of giving their students more hands-on experience, so getting them out of the classroom. And so clinical teaching has become mainstream in law school these days. I always sort of think of it as like, when you're in medical school, you spend your first 2 years in the classroom, and then you spend 2 years doing rotations in the hospital. And that's sort of the opportunity clinics offer law students, an opportunity to actually be little lawyers for a while and litigate real cases. And so this case was one that came to us through the law clinic. And at the time, of course, I was, did all public wildlife and public lands questions. I'm trying to figure out how I can best change the slide. I'm sorry, I don't see the control. There we go.
And Michael, so sorry. I think there's a little difficulty in hearing your audio. Is it possible to maybe move a little closer to the mic or?
Sure.
Yeah, perfect. Thank you.
Usually not a problem that I have. So I will try to speak a little louder. So one of the things that was really important for us, I just want you to know, is that we didn't want the public to see this as us having anything to say critique on the art itself. This was a public lands issue that was near and dear to my heart and my students as well. And so I'll still say to this very day, I'm sorry, Bob, but just listening to you, it still hurts thinking about the types of, even the mitigation that had to be done on public land to carry something like this. It's something that I strongly don't support. I strongly don't support these kind of projects on federal land, particularly in areas like this one, which have such great value for wildlife and recreation. And as it was alluded to, it's still, I think, to my knowledge, this is the first and only art project that required compliance with the National Environmental Policy Act. And I agree. I think throughout the process, it was very clear to us that the artists themselves embraced this as part of the art and said so and was willingly going along to comply with it. But for us, it was the intensity of the project. It was the fact that it was the only art project to require an EIS spoke volume. Because usually EIS is on public lands like this. We're talking about major oil and gas and mineral development projects. And so we related the impacts from this art project to that type of industry impacts. And if you know, a lot of focus on the project was on the short-term nature of this 2-week period and how great that will be for the state, for tourism and recreation, but for my clients, but also for myself and the students working on this case, it was that industrial nature of that 2-year construction project. And you can sort of see what that amounted to. I mean, this is heavy industry stuff. This is the type of things you would talk about in developing an oil field on public lands. It's not just the 5.9 million miles of fabric, it's the anchor transition frames, it's the boring into the side of the canyons. It's the fact that, by the way, those borings would be left behind, steep dirt over them and some seeding to try to revegetate. It was the steel cable, it was the panels, it was all the construction workers in this canyon for 2 years, all the equipment that was going to be brought in there. These are things that, from just the standpoint of wanting to protect public lands, is somewhat difficult to take. But also, as you're going to see, public lands are regulated not only by NEPA, but by the national, the Federal Land Planning Management Act, which tries to sort of, in a way, zone or restrict what kind of activities can take place in certain areas. So for us, it was both legally problematic, but also just problematic for respect to the impacts on wildlife and the environment. Now, here, by the way, this is a excavator with a hydraulic drill to put those. This is how anchors are placed in the side of canyon walls. So this is the sort of type of construction you would have seen in there for a period of 2 years. The area itself, as I said, is regulated by BLM under FLPMA, and there's a resource management plan for this area, the Royal Gorge RMP. And an area within the Royal Gorge RMP area is this Arkansas Canyonlands area of critical concern. And this is an area where you wouldn't see this kind of industrial construction. In fact, one of the reasons for labeling an area an ACEA would be to sort of zone out this type of heavy construction. It's an area where you're supposed to pay attention to protect and prevent the irreversible damage to the values of that ACEC, which in this case was cultural, wildlife, recreation, and those types of things. In fact, there was a specific management directive that our case really focused around, in which BLM was obligated to both protect and enhance scenic, historic, cultural values, raptor habitat, falcon habitat, bighorn sheep, the fishery, and then recreational access. To the extent that things were sort of contemplated by BLM in its resource management plan, it was more light to, sort of called mid-weight type of recreational activities, kayaking and rafting and hiking and all that type of stuff. There was limited off-road vehicle use in some of the areas. That's pretty typical on BLM land. The plaintiff in this case, who came to us in the clinic, were a group that formed, mostly they were local residents. The map that you saw earlier from Jonathan showed a number of small communities going up US 50. Most of the members of ROAR were residents in that area. Their concerns were varying. Some of them were just really concerned about the disruption of life, particularly during the construction phase. Some of them were concerned about access to the canyon by emergency vehicles. There were going to be at least 177 days of anticipated one-lane closures. A lot of the pullouts would be occupied by the construction equipment. So it certainly would have impacted life. But a good majority of them were also concerned about the types of things that were supposed to be protected by BLM. Access to the river, impacts to the wildlife. We already heard a little bit of what Bob said about the needs for bighorn sheep to get to the river. But you remember, it's also the bald eagles, the golden eagles, the falcons, the ospreys. They rely on the access to the river for their nutritional needs, and it's not just the fabric, it's just all that commotion down there for 2 years that's going to scare them away and have them relocate, and potentially even result in them not having successful breeding cycles and that type of thing that we were concerned about. And then fish habitat as well. Fish habitat in the river, and by the way, it later received, I think, a silver star, like fishery is one of the most important in the United States, can be very disrupted by that type of activity along the river. And the panels themselves the water temperatures and fishery temperatures are very narrow, and they can be subjected by that type of fabric over the river during the periods of time of display. So there was a lot of concern by ROAR over those issues. So we filed our lawsuit in the U.S. District Court on February 2nd, 2012. My son was a month old that day, so I remember it well. These are the two DU law students here, Justine Shepard and Mason Brown, who worked on the case for the first year. This case went on to 2016, so we had probably a total of 10 to 12 students over the course of those 5 years work on this case. Joan Azimo was the ROAR spokeswoman who was doing this press conference, and I'm obviously hiding out behind everybody back there, not to be seen. Let the students do the heavy lifting. The litigation itself. So we originally filed in the federal court. We filed claims under NEPA and under FLTMA. The court decided that, so it took 3 years for the district court to decide the case. I think it was decided in January of 2015. When we got the opinion, it was pretty apparent that the court focused almost exclusively on the NEPA claims, and we lost. And when it got to the FLTMA claims, it seemed to be sort of an afterthought by the court. Very little time was spent. In our minds, I think going into that case, we really thought the FLTMA case was the strongest of it, and not the NEPA. And I'll tell you why in just a second. So when we filed our appeal in the 10th Circuit Court of Appeals, we went ahead and abandoned the NEPA claims. We didn't want to have that mistake bite us twice. So we focused solely on the compliance with the Federal Land Planning Management Act. And for us, it was sort of a real quick three points that we wanted to make. One is that generally, to authorize a project on BLM lands, whether it's an ACDC or not, you have to have some type of component that allows for it, that expressly allows for it within the RMP. That was just not the case here. I don't think there was any disagreement among anybody either on this panel or in BLM that the Royal Gorge RMP didn't provide for any type of industrial size art project or anything like that. And there was some talking about comparing it to the Burning Man, or where events are filmed and movies are made and that type of stuff. And we pointed out that if you go and look at the resource management plans for Burning Man, et cetera, they have an actual component in the RMP. It was part of the planning process. Burning Man is built into the RMP, and a lot of other BLM lands have permit processes for filming events and all kinds of stuff like that. That was lacking completely here. That doesn't mean that just because the RMP doesn't provide for it, that it can't be approved, and that's the second point. BLM can still approve a project that isn't specifically stated in the RMP, but it has to make what's called a clearly consistent finding, that the project would be clearly consistent with the overall intent and requirements in the RMP. And this is where it got dicey. And I saw this question from Devin earlier. That's a tough question to answer in a panel like this. But I will say that we know for a fact that looking through the record in this case, and the record was tens and thousands of pages long, it was massive. that early on, those who were asked to do the analysis of this project said, this is not consistent. This is just not consistent because the only thing contemplated in this area is light recreation and wildlife protection. And this is not consistent with that. And through, I will just say it, through political pressure, this growing coalition that Bob talked about of people who supported it, BLM was feeling a lot of pressure to do something about it. So this idea came out that, well, if we label this recreation, then it's at least consistent with the recreational aspects, or as they said, not inconsistent with the recreational aspirations of the RNP. We don't think not inconsistent is the same as consistent, but that never was decided by the 10th Circuit. But that was our view, and we felt strongly that, that they never had really made that determination, that they had sort of skirted it. And by the way, it was interesting because the record also makes it pretty clear that the artists themselves did not want this to be recreation, but that's not how they viewed it. This was art. And it was only BLM saying, well, we can't do the art one, we have to do something with recreation, that they were able to work it into the final EIS and then record of decision. And then we also, our third point is just, we just felt that, and this I think struck home. I felt like for me, this is my memorable moment in the oral argument in the 10th Circuit. I kept saying that to protect and prevent does not mean to allow intentional damage first and then cover it up later. And I remember Judge Henery repeating and mouthing those words, oh yeah, intentional. Because a lot of focus was on the fact that they were going to cover up the boreholes and put new seeds on there. And we're like, yeah, but you never protected and prevented the damage. You allowed it to happen. It was intentional. And that you just can't read FLTMA that way. And that was when I left the 10th Circuit argument, I felt we had struck something on that. For those of you who don't know, this case was never decided. It was argued, I believe it was in the summer of 2015, just before the election. I can't know, maybe that was 2016. I can't remember the dates exactly. But we had argued the case and we were waiting a decision. We had been waiting for quite some time. I think it was pretty close to being written and out when we had our election results in 2016 and Trump was elected to office. And the artist did not sit well with that and decided that he didn't want to build a project here in the United States and wanted to withdraw. And so we ended up doing a settlement where we never got an opinion from the 10th Circuit. We got the district court's decision vacated on the NEPA part, on the FLTMA part, and they agreed not to come back and ask for a permit, in 4 years after Trump was gone, that they would walk away permanently. And that is exactly what happened. And I still weep to this day that I didn't find out what the 10th Circuit was to say. But, my clients, I have to say, I'm sorry that this doesn't sit well. But obviously, they felt that they lost a lot of battles, but won the war. And with that, I could turn it over to you.
Thanks, Mike. I'm mindful of time. I get to sort of close out the panel discussion, and I wanted to spend my time focusing on some of the incredibly unique legal work that we had to do to try and fit a public art project into the two statutory frameworks that Mike's already referenced, FLTMA, the Federal Land Policy and Management Act, and NEPA, the National Environmental Policy Act. So I wanted to talk to me first about what for me was really the most extraordinary opportunity as a lawyer to work through this. And again, our firm, Kaplan Karsch, was lucky enough to be hired to represent the artists to secure the federal approvals. And so it remains one of the most extraordinary projects I've ever had the opportunity to work on. But I wanted to tee off of one of the topics that Mike was just talking about, was this sort of curiosity of figuring out how to frame what type of project this was when we looked at it under the rubric of the FLTMA statute. And just by way of background, FLTMA, again, the Federal Land Policy and Management Act, is the act that regulates the ownership of public lands, largely in the West. And in general, the statute sets up what we call a multiple use mandate for federal land managers, in this case, the Bureau of Land Management. And it's a complicated mandate for agencies to deal with because on the one hand, they have to support recreation and a fair number of what we would call sort of environmental issues. How do we protect the fishing? How do we protect the rafting? How do we protect the access to this unique area, including the ACEC? On the other hand, there are more, additional uses that BLM has to support. There are hunting seasons in the Royal Gorge area and hunting seasons for bighorn sheep. There are off-road ATV access issues, and the BLM is charged with sort of figuring out how these all work. And under the statute, each land management agency identifies what Mike referred to the resource management plan, or the RMP, and that's sort of the guidelines for the particular area. And the land management agency needs to look at those guidelines to figure out, is a proposed project consistent? And for me, one of the most interesting things here was, and Mike, you alluded to this, what is this project and how does it fit in with the types of activities that we are seeing, in the Royal Gorge RMP area? And for me, one of the most fascinating things was to see BLM really wrestle with what is this and how does this fit? And as Mike alluded, at the end of the day, the agency concluded that this was a recreation activity. But if you look at the record, you see BLM wrestling with this, and I'm going to read a couple of quotes, and acknowledging that the RMP here emphasizes developed recreation, which is defined as non-wilderness recreation or recreation with a built or human component. And the BLM reads that and concludes, and I'm quoting here, "I find it difficult, if not impossible, to conclude that Over the River is not consistent with the RMP goals." We can agree to disagree on whether that's correct, but for me, one of the interesting things as a lawyer is to figure out how are we wrestling with those definitions and figuring out what's meaningful here. The other thing that I thought was fascinating that arose under FLIPMA was one of the mandates that BLM has is to assess impacts to visual resources. And BLM creates what's called a VRM, or a Visual Resources Management Plan, which is a program to identify resource values and to establish procedures and objectives to manage those values. And there are a lot of things that federal land management agencies do that are a lot easier to get your hands around, how many days of impact, how many rafters, but assessing visual impact qualities and values is a lot more esoteric. And for me, one of the interesting things was to look at how BLM analyzed the visual resources in this corridor and whether or not this project was consistent with it. And if you look at BLM's manual that talks about how to assess these characteristics, I'm going to read some of the language. And it says that the VRM, again, the Visual Resources Management System, is designed to separate the existing landscape and the proposed project into their features and elements, and to compare each part against the other in order to identify those parts which are not in harmony. Then ways are sought to bring them back into harmony. This does not sound like traditional government regulatory speak. And what's very interesting to me is how close these kind of BLM guidelines come to the artist's vision for what they're doing. So you see the VRM manual talking about this concept of harmony with the landscape. And the manual defines harmony as a combination of parts into a pleasing or orderly whole. Congruity, a state of agreement of proportionate arrangement of form, line, color, and texture. And I think it's interesting to contrast that against the vision statement of the artist, which is to use the natural beauty of the river, which is part of the temporary work of art, with translucent fabric panels, emphasizing the configuration, color, texture of the river as it meanders. I've never had the opportunity to work on a project where we get that kind of concurrence and we have to be thinking about art and visual harmony in the context of federal regulations before. And for me, that was one of the most interesting things, as an attorney. So again, let me put this back in legal context. Mike alluded to the fact that one of the issues in litigation was whether or not the project itself was consistent with the federal land management Act and with the Royal Gorge RMP. At the end of the day, the BLM concluded it was. The district court upheld that opinion. And again, we did not get a final decision from the 10th Circuit because the project was pulled. I want to switch quickly and talk about NEPA. And for those of you who are not as familiar with NEPA, NEPA is the National Environmental Policy Act. And it's one of the most interesting federal environmental statutes because unlike many of the other statutes, which we call command and control statutes like the Clean Air Act, set standards, don't exceed these, so on and so forth, NEPA is first and foremost a procedural statute. And the policy goals behind the statute is to ensure that federal agencies make informed decisions before they take major federal actions that may impact the environment. And so NEPA doesn't command a particular result. Rather, it requires an assessment of the extent of potential environmental impacts. It requires a public process to ensure that the public is aware of what's going on and an opportunity for comment. And I think one of the successes of the statute is that as a result of the public process and as a result of the analysis that's done, we see federal land management agencies, federal agencies reviewing projects, identify mitigation methods, either to bring the project down below a threshold of significant environmental impacts to allow them to proceed with a lower level environmental review called an environmental assessment, or in the case of a project that may have significant environmental impacts, to at least ensure that the public and the federal agency is fully aware of the issues at stake. One of the curious aspects here was that this project started as an environmental assessment, the lower level review. And again, under the statute, you can prepare an environmental assessment if you don't believe that there will be significant environmental impacts. And at the end of the day, if the agency can conclude that there are no significant impacts, a full environmental impact statement is not required. Here, the artists actually sought to elevate to a full environmental impact statement, which I can tell you never happens. Industry does not do this. So it was a very curious client to have in that regard. They anticipated litigation. They anticipated strong concerns from community. And they really wanted to go, as Bob said, they really embraced this process of wanting to do the full, robust analysis that would provide a full record of all of the issues. And as Jonathan described early on, the analysis covered the full extent of the project, from the construction, from the, what would be required, how we would get there, how traffic would be impacted. All of these things were studied over the course of the 20 plus resource categories that were examined in the BLM EIS. I wanted to talk about some of the sort of curiosities of examining a public art project in an EIS, which again, this was the first ever. And for me, one of the most curious steps was at the beginning of the process for any NEPA project. Again, this is assessing environmental impacts from a project that requires federal approvals. The first thing that the federal agency has to do is define what is the purpose and need of the project. Why is the federal agency reviewing this? What will it benefit? Why are we doing this? So on and so forth. And as a legal matter, what we call the statement of purpose and need becomes a critical element of the environmental impact statement because it defines the scope of reasonable alternatives that need to be studied in the document, which is an obligation under the statute. And one of the things, and Jonathan, you didn't highlight this, but one of the things that's unique to the artists was that it's very important to them to have their projects be temporary, 14 days. And as their attorney, one of the issues we had to advise them was the statute is going to require that a full scope of reasonable alternatives is studied. And one way that you might mitigate impacts to this project is extending it so that people have a longer period of time to visit, and that might mitigate traffic impacts. And so I was tasked with talking to Christo to understand why 14 days. And his answer, which I will always remember, was because of the tenderness of time. which I thought was beautiful from an artist perspective, but it's not something you can go back to the federal government with. And so let me assure you, we had to study different time frames because that did not translate sufficiently into purposes and needs from a federal perspective. I think the other thing that you raised, Mike, that I wanted to talk about was, the concern about impacts. And so and again, I referenced this earlier, I think one of the successes of the NEPA statute is it forces the agency and the project proponent to think about mitigation conditions. And at the end of the day, here, Christo and Jeanne-Claude committed to an extraordinary number of mitigation conditions. Bob already talked about a number of the conditions that were imposed in order to protect the bighorn sheep population. There were extraordinary restrictions placed on the construction period to avoid migratory bird season, to avoid the eagle roosting and nesting seasons, limiting traffic construction activities on the US 50 side during the summer recreation seasons. At the end of the day, I think there were maybe 3 months in the year during the construction season that were not subject to some kind of mitigation condition or another. And so the installation period really extended in order to take a lot of those conditions into effect. I want to be respectful of the time because I know we only have a couple minutes left. I did see Devin, your question about how accurate do you think environmental impact reports are? And do they work to legally protect the environment? Again, in the NEPA context, this is a procedural statute. There is no mandate under the statute that to be approved, the project can't have environmental impacts. What the statute does is to require that the impacts are considered before the approvals are done. Does the accuracy depend on who's on the team? Probably. I think here, and Bob referenced this earlier on, I think here we had a project proponent that was extraordinarily mindful of the impacts of this project and willing to commit to mitigation measures and figure out how to work with regulators to minimize those impacts and to agree to restoration plans and procedures to mitigate the effects of this project. At the end of the day, we didn't get an opportunity to see the project realized, but I'll close by simply saying it remains one of the most extraordinary opportunities I've had as a lawyer to have to think incredibly creatively because I had a client that came at these statutes from a much different perspective than most clients approach NEPA and FLIPMA. So I'll stop there because I know we're incredibly short on time.
Thank you. And Jonathan, I think we wanted to just circle back to you for maybe a minute or so, and then there are a few other questions, and I'm happy to share those with you. And so sorry, I think you're muted, Jonathan.
Yeah, I'm in an office. Yes. Okay. So thank you for Mike and Bob and Katie for covering all these things. I didn't, even though I could probably speak about Over the River for about a day straight until my voice stopped functioning. And yes, those mitigations did add a lot to the cost of the project, potential cost of the project. And in fact, as you mentioned, Katie, the construction schedule, because of the restrictions on lane closures and timing, added literally probably a year or more to the construction schedule, which in turn could have created a greater impact for the people in the valley because the construction would have lasted much longer had it been in a. But the artists, like you said, agreed to every possible mitigation, and as they wanted to make sure that this would go through. This project remains one of probably the best known non-realized Christo and Jeanne-Claude project. As any artist, they don't get to live to finish everything they do, and sometimes, in this case, they change their mind and abandon the project. But to this day, these original drawings and collages are in museums and private collections globally in the United States and in Europe and in Asia. And you'll see them, of course, in the National Gallery and at the Smithsonian, these pieces. So they are part of art history and are now part of environmental law history.
Thank you. Thank you so much to all of our speakers. This has been such a fascinating talk and one of the first that we've had on art environment and these types of projects. So I think we're going to have many, many more to follow this. Maybe a couple of very quick questions because I know we're at time, but we're curious about thinking just your thoughts on the controversy, the legal battle around this. How do you think it's added to, detracted from the artistic legacy of the artists?
That's a good question. Oh, you asking that for me? Yeah.
Yes, or any of
Being that
the.
I'm on the board of the foundation of those artists, right? So it does show what kind of people they are. That the determination to try and do things that are difficult to do, that no one's done before, that sort of redefine how people view spaces, whether it be wrapping the German parliament, that wasn't easy to get permission to do. But it also shows that first they were artists, and they do what they want. So they don't always get to, but in this case, they canceled something. Christo canceled something that was very dear to his heart. Jeanne-Claude being already deceased by that time, I don't think that affected it, but it also, he had in mind that he would like to realize some projects and not spend his last decade in court defending one. It's, as much as it may have been a disappointment to all the friends in Colorado, and a cheer for a few people in that valley, as we know. This really shows what it means to be an artist.
If I can just say, I mean, I really meant it when I said that we tried to really not make the art or the artist essential to our litigation. I mean, it's easy when you're challenging an oil project on federal lands to, speak freely about the proponent of the project. And there was never any of that. I think we respected the person and the concept while feeling that the place was inappropriate. I just want to make that clear. And that was difficult because, like I said, it's usually easy to villainize the person that's proposing something like this.
No, Mike totally understood that, and that, as you mentioned, it became part of the process of the work, and actually the fact that it was challenged to that level to make it to the federal level actually, was a source of pride for the artists, as you probably know.
For me, one of the most interesting things was how robustly Christo and Jeanne-Claude embraced the public process that's called for in NEPA. Most project proponents find it aggravating, it's annoying, it's an extra step I don't want to have to do. But and Jonathan, you just used the words. For them, it really was a part of the process, and it made people talk about art, and it made people respond to art, whether they liked it or didn't like it. Almost came across to me as though that was a bit of the success of the project. It was making people think about the things that he was envisioning and react to it one way or another. And, that was a very unique happenstance for us.
And more to that point, Katie, as you said, it was unusual. It challenged lawyers to think about things a little bit differently, these statutes that, we've all kind of become accustomed to talking about and arguing about. It really stretched the limits of bureaucrats' ability to think somewhat creatively and artistically and freely. And that included, people like me based in Denver. It included the state patrol lieutenant based in Chaffee County who was thinking about traffic management. It included county commissioners, with dirt on their boots, thinking about, here we have an international artist coming to these communities. So it was exciting in that way. It was just, it was kind of a once in a career, once in a lifetime type of project to work on.
Thank you. And I know we're at time, but maybe just the final question to close us off. If the project had been realized, do you think the public perception of the project would have changed, or what would have happened?
I would have loved it. I would have loved it, but I'm not the artist. But certainly it would have been. I can tell you from history and other projects where every one of these major installations, these temporary installations, there's always a difficult period of trying to get permission to do it, and there tend to be some converts because people enjoy it once it's up. So it probably would have been it would have been much more positive. Certainly not everyone would have liked the looky-loos, and causing traffic jams along US 50 and the county roads there. But in general, I think the bigger world would have applauded our country and the state of Colorado for re-envisioning a way that artists could sort of have the same rights and uses for public land that other that forms of recreation do, whether they be hunters, fishers, boaters, campers, hikers.
I'll say, I think it would have been really challenging as a project to realize. I think the constraints of Highway 50, I think the engineering, I think the weather through the canyon. I mean, it would have been exciting to see. And frankly, having heard Christo and Jeanne-Claude talk about this project and others kind of over the years at presentations and public meetings, that too, frankly, was part of the art. All of the challenges that go along with realizing it. So I'll just say, I was excited to see it built, but I was a little nervous about just the possibility of things to go awry and to be challenging.
I mean, I will add, one of the last things I worked on for the project was post-ROD coordinating with all of the emergency managers on the emergency management plan for the project. And it was a daunting task to think about all of the things that law enforcement officers, that safety officers, that fire officials, I mean, all of the issues we had to think about for how to make this come across successfully. It was a process we began and didn't have the opportunity to complete because the project was forestalled, but we were beginning to dive into that, and it was going to be a Herculean task.
Thank you all so much. Sorry we went a little over time, but there's been so much interest in this topic, and I feel like we're going to have to cover more of these conversations and these types of artworks and these projects as well. But thank you so much to all of you, Jonathan, Bob, Katie, Mike. This has been really a fantastic conversation. Thank you for your time, and I will share a recording of the session to all who have attended. I've also sent a short survey in the chat as well. We would love to know your thoughts on this this discussion and what you would like the center to cover next. So we hope to hear from all of you. And once again, to all of our speakers, cannot thank you enough. We appreciate it. Thank you.
Thank you
Thanks,
so much.
Atreya. Yeah,
Take care.
take care all.
Bye now.
Bye.